if the offerer, if you are making the offer, makes an objection to the additional terms, then they cannot be included in the final agreement. And if the other party insists on those additional terms, then it becomes a counteroffer. So the original offer is defeated, and you have to go back to negotiate and decide whether you want to accept those. Now, if you objected to those terms, you probably don't have a deal. The other issue comes up: what if the additional term injected by the offeree, the person making the acceptance, is a material alteration in the offer? For instance, we discussed arbitration clauses earlier, right? Very common. But if in the offer you have not included an arbitration clause, and then they come back in the acceptance saying, I do want an arbitration clause, or I don't want an arbitration clause, but that may be a material alteration in the original offer. So, but if it's a minor term to which the offerer does not object, let's say the acceptance comes through and says, I want delivery in 15 days instead of 30 days. And then if you don't object, well, that's a minor alteration, and it could be included in the final contract. Now, the other issue that comes up in these issues of injecting new language in the acceptance, one thing which defeats that, the ability to do that at all, is that performance is already done in the contract. And on some invoice that they send a month later, after you've shipped everything and perhaps begun actually using what you shipped in order to build something or remodel or refurbish something, they cannot now inject any new written language. So this is one of the unusual aspects of American contract law, where usually we say the written word takes priority over any oral agreement. Not so if the oral agreement has already produced performance by both parties, or partial performance. You cannot interrupt partial performance by throwing in a new written clause in an invoice or contract. Any comments or questions on any of that? How many of you have sort of handled or negotiated contracts? And just wondering if you encountered any of these issues before?
Yeah.
Yeah? So, I'm right? Don't you?
Yeah, but mostly we just, I mean, it's usually our contract, and we just don't accept modifications for us, so.
And they're all kind of boilerplate. So each party knows what the other is doing. So you don't have conflicts in these issues. Right.
So what happens, it says that counteroffer should be clearly stated, but what if it isn't? So let's say I get sent terms for a contract, and then I try to sneakily rewrite the contract, and then you sign it without your knowledge that I redrafted it. Well, what happens?
Without knowledge that you have sneakily
Yes.
revised.
I changed a couple of the words around to fit my needs a little bit better. And then I presented it as the same contract.
Yeah, well, if they sign it, they're not showing due diligence by failing to examine any changes that you made in the contract.
So would they be held responsible to that new contract?
You could hold them responsible. Now, they could, if they found that there was some fraud involved in your action, or unconscionable action on your part, then they would use that as an excuse if later on they discover that after the fact they discover something they should have discovered before the fact, and they don't want to comply with the terms of the contract. So you got to be careful when you talk about changes to or forcing something on somebody else, because then you have the excuses of duress or undue influence.
Okay.
If you're using either of those, what is the difference? We have a slide on that too. Duress is when you're actually coercing somebody through threat.
Yeah.
And that could be a threat of physical force, it could be a threat of litigation, it could be a threat of a lot of things.
Okay.
Undue influence is when somebody who has a fiduciary relationship to the other party or a relationship of trust uses that relationship in order to pressure them to take an action or strongly advise them to take an action.
Okay.
And that's why accountants, ministers, doctors, any clergy, they have to beware of that because they are giving advice and you, of course, are trusting them because of their professional position. But that could be considered undue influence, which would allow you to escape your obligation on the contract if you signed it due to that advice. Okay? Battle of the Forms has one other thing, and that is if two terms are exchanged between offer and acceptance, which are directly in conflict. And there's one wonderful case here, Richardson versus Union Carbide Industrial Gases, which had to do to a pre-printed contract created that doesn't create an enforceable contract. I don't have the result in this case, but the result was there was a majority view and a minority view. That is, a majority of most opinions would say it's the offeror's language that should take precedence. The minority view among other courts was no, it should be the language proposed by the offeree, though that party making the acceptance, that should take priority. And what did the judge say? The judge said, I don't think it's fair to go along with either. So I'm going to suggest gap-filling provisions, which sort of split the difference between the two terms made by the offeror and the offeree. So that's another thing that oftentimes is done under the UCC when judges are allowed to use their own discretion to make these gap-filling provisions when there is a disagreement. So then you should plead with the judge, plead your case, that yours is the most, to try and opt more closely to your language than to the language of the other party. Warranties come up. I think I'll leave this until next time to save time, because this is a product liability issue, so it really belongs on Wednesday as well. Different types of warranties. And the McNeil case I'll get back to as well. This was a slide on having to do with assent. Did you assent to the contract? Undue influence and duress are the two issues that I just discussed. And then you have the issue of adhesion contracts, which are typical in, let's say, lease agreements when you're leasing an apartment. Do you sit down with the landlord and negotiate over clauses in the contract and say, I want to blow out the walls with my stereo. I really don't like these noise restrictions. No, obviously they are going to impose the terms of a reasonable, quiet, whatever, on a take it or leave it basis. And those are considered, it sounds like illegal, it's not. Those kinds of adhesion contracts in those circumstances are okay. And then unconscionability, just a repetition of that to remind you. Now, in terms of complying with a contract, whether it's enforceable or not, another excuse not to perform would be, well, there is a mistake of fact. This doesn't come up too often, and I'm sure it doesn't in your contracts that you sign. You know what you're bargaining over, you know what you're going to deliver, what the other party is going to provide. But there can be either unilateral mistakes or mutual mistakes of fact. If it's a unilateral mistake, it's usually not an excuse not to perform on the contract. The party cannot avoid it unless, one, the other party knows of your mistake and they're taking advantage of you, or it is a mathematical error or inadvertent. And that can happen in contracts, you just made a mistake. And in that case, they would say, well, that's okay. But if it's a unilateral mistake as to fact or value, they usually will not. They'll say you should have known better. Sure. But if it's a mutual mistake of fact, one party thought a word meant something and the other party thought the word meant something else, then you've got a basis for rescinding the contract. Now, the classic English common law case, wonderful case, Raffles versus Whipple's house. They were trying to ship, back in the days of the old British Empire, ship goods from the Bombay Company in India to the United Kingdom via the ship Peerless. Problem: 2 ships named Peerless, one of which was going to dock, I think, in October, and the other one was going to dock in December, or leave in December. And then, so they show up in December, saying, here are the goods, pay up. They said, well, I'm not going to pay. I expected that in October. You have to pay. No, because of the mutual mistake of fact. Now, there would probably be some arrangement in negotiating and resolving the dispute based on what we would call balancing the equities. What is fair to each party here, because each party may be at a partial loss. But, so you have to be aware of very unusual things like that. Okay, the rationale. As I said, I think last time, the parole evidence rule is to say that you can make no oral modification in a written contract. However, as we said earlier, if you are already performing on an oral contract, then you cannot make written adjustments later on, so beware of that exception. Okay, parole evidence establishes, however, that there is no mutual assent to a mutual mistake. In the case of ambiguity in the contract, where one person says Peerless 1, the other person is thinking Peerless 2, then you can introduce oral evidence of what you meant and what the other party meant to revise the contract after the fact. Okay, the statute of frauds, not a big deal, just there are certain contracts that have to be in writing. This, by the way, is not true in international law under the Convention for International Sales of Goods. It is much more liberal in terms of enforcing all kinds of oral agreements, even those involving interests in land or the contracts for the sale of goods over $500. If they're oral under international law and each country is a signatory to the CISG, Convention on the International Sales of Goods, they will enforce it. But otherwise it has to be in writing. And guarantee contracts. When you substitute your will to perform on a contract that your friend or relative or whoever has decided that they will not perform, you're guaranteeing, I will perform if they don't. Now, why does that have to be in writing? Because if you simply say that, it's a gratuitous promise. It has no consideration behind it. So they would force you to, and we talked about consideration last time, that should be definitely in writing. And then a performance and discharge, different levels of performance. Obviously, you want complete performance, but you could enforce a contract based on substantial performance. That is, if there are minor deviations which affected the value of the performance, then the other party might have to compensate you for the difference in the value that they provided and the value that you wanted. And it could just be a certain amount of money. This is a case very similar to the contractor-subcontractor case we discussed earlier. Subcontractor here installed pipe, not of reading manufacturer, that is a specific brand name that was specified in the contract, but was of similar quality. And this person comes back later and says, well, you know, you didn't supply it, so what I want you to do is to strip out all the piping in the contract and replace it with that of reading brand of pipe. And the court said, that's unreasonable. No difference in quality. So what are we going to do in your breach of contract suit? We're going to say you won. You made, yep. Well, what kind of damages do you get? What we call nominal damages, which is zero. You get nominal damages. You won a Pyrrhic victory here in court. So the oral verdict for the defendant was struck down on appeal. Now it's reinstated. Substantial performance and consideration of fairness dictate the measure of damages should be the difference in value, nominal, not the replacement cost. There was no real difference in value. So you don't want to go to the mat on something which, of course, doesn't reward you any money. Okay, now,